Now is legal analyst and local attorney Barry Covert to help us understand this. Barry, we've turned to you a lot over the past couple of years in terms of kind of understanding bail reform and some of the proposed changes. When it comes to tweaking the law, what the governor said today was she wants to eliminate the, quote, least restrictive standard for bail eligible offenses. I wonder if we could just start here with that part of what bail reform did and what it told judges.
What bail reform did in general is for nonviolent offenses, judges were told you should not set a bail, just release the defendant, largely for nonviolent, lower level offenses. For more serious violent offenses, where you have your murders, your rape, your very serious charges, judges were permitted to set a bail, but they were also instructed by statute that they are supposed to set a bail or conditions that are the least restrictive to impose, that assures that the defendant will return in court. So what we normally consider to be the factor of dangerousness, will that individual go out to society and commit another violent offense? Is he or she a danger to a spouse in a domestic violence case? Those factors were not supposed to be taken into effect in determining what is the least restrictive means on these violent felony offenses to make certain that the defendant returned to court. Governor Hochul has now stated that she would like to renegotiate with the legislature that language and no longer require that the bail or conditions for the defendant's released are the least restrictive means. In other words, the judge can take into account both the issue as to how do I make sure that this defendant returned to court, but also take into account, is this defendant dangerous to others? Is there a history of violence? Is there a particular concern here, for example, in a domestic violence case, that this individual is going to again engage in the same conduct? And she would like to open up the doors to renegotiating that language so that judges can use a broader spectrum of issues to review when deciding what the appropriate bail is, if any.
Yeah, all about the amount of discretion that's given to judges here, and the governor talked a little bit about that today. Let's listen to part of her speech from earlier.
I would say we can agree that the bail reform law as written leaves room for improvement. And as leaders, we cannot ignore that. When we hear so often from New Yorkers that their top concern is crime. Of course, we know that that won't automatically bring down crime rates. We don't expect that. We also have to make sure the law is clear for our judges and what their rights are and what their expectations are.
So, Barry, we've heard from, for instance, Erie County DA John Flynn, who has called for changes to bail reform. He thinks there have been some cases that have sort of slipped through the cracks here. Oftentimes, you're on the other side of that debate saying, look, the point of bail is just to make sure that they come back to court unless they're, a severe danger to the public. So what do you make? I'll ask you for sort of the opinion side of this, or you as a defense attorney, what do you make about reopening this again and perhaps tweaking it further?
Well, this would be the second set of tweaks, and this would permit judges where you have cases where the judge believes that a defendant could be violent, has a violent history, could engage in the same conduct. There's some other extenuating circumstances that lead the judge to believe that he should or she should exercise their discretion in setting additional conditions, and not just the least restrictive means for return to court. I believe that where you have the nonviolent offenses, we absolutely should make every effort to release the defendants either with no bail or the lowest possible bail. But if you have violent defendants, or you have a reason to believe as a judge, after hearing both the prosecution and defense present their arguments to you, that that individual has a strong likelihood of immediately engaging in further violent conduct, going back to their spouse on domestic violence cases and causing harm, where such a showing is made, it's not unreasonable to give judges that discretion to try to make sure that they protect society.
So finally, Barry, before I run out of time, this was such a big issue politically in the governor's race, which was a lot tighter than I'm sure Governor Hochul would have liked for it to have been in a state like New York. Do you think it's possible as they go in and tweak this that they can eliminate some of those circumstances in which you have these stories making the news all the time of someone who's out on bail who a lot of people think shouldn't be? Is it possible to find that sweet spot in the middle between maybe the two extremes?
It's always hard to predict what politicians should do, but I would think that given some of the examples, very, very tragic, unfortunate examples that have occurred since the Bail Reform Act, and there are not many, and the Bail Reform Act by and large has been very effective in releasing indigent defendants that are charged with nonviolent offenses without any bail. But where you have violent defendants who have a history of violent conduct or domestic violence violations that endanger their spouses, I would think that the legislators could all come together and find reasonable types of legislation that would do it. I know Monica Wallace, our local assembly person, has strongly fought for some changes to the Bail Reform Act. I think that others will as well. It's hard to imagine that reasonable people cannot agree that violent criminals with prior histories, or there's a reason to believe that they're going to engage in this conduct again, should not be treated differently than nonviolent offenders.
We will continue our reporting on this tonight at 11. Our Andy Payton with a follow-up report. Something we'll certainly be following. Barry, always great to get your insight. We appreciate it.
Thank you.